Okay. In the today's presentations, I am presenting on the topic much of proof in the court proceedings of the relevant facts and disputed facts, whatever the parties to the suits or proceedings, they haven't either asserted by one party or denied by the other party. Here, now, on this topic, much of proof, we have to see the details concept of the oral evidence, documentary evidence, and under the concept of the documentary evidence, the primary evidence and the secondary evidence. These concepts we have to be clarify ourselves. Here, at first, we have to know about the modes of proof in court proceedings. Here, in the court proceedings, whatever the parties they have asserted or denied about the disputed facts or about the relevant facts, it can be proved by two modes. That is, one is by producing witnesses. That is, here these witnesses they will give statements, they will give depositions before the court proceedings, whatever they have seen and whatever they have heard, whatever they have perceived with their own five senses. That is, here these depositions by producing witnesses before the court proceedings is known as the oral evidence. There is a direct evidence. And another mode is by producing documents for the inspections of the court. Here, under this production of documents, here there are there are two concepts of documents. That is, one is the primary evidence, and another one is the secondary evidence. By producing such primary evidence, and in some circumstances, when the original documents is not possible for the productions before the court proceedings, then under these circumstances, secondary evidence it can be produced for the inspections of the courts. Here, this is the details, the basic concept of the modes of proof. By this US, by this modes, whatever the relevant facts, and whatever the disputed facts, it can be proved before the magistrate, before the court, before the judge. Okay. Now, uh, now the related provisions we have to see here. Section 59 it provides about the proof of facts by oral evidence. Here, this section reads as all facts except the contents of documents or electronic records may be proved by oral evidence. Here, this section expressly provides that whatever the facts, relevant facts, it must be proved by oral evidence. That is the by productions of the witnesses. That is called the oral evidence. Except the contents of documents or electronic records. Excluding the contents of documents or excluding the electronic records. Yeah, all the facts, relevant facts, it must be proved by the producing witnesses. Here, section 59 provides about this. Now, this section 60, you see. Here, oral evidence must be direct. Section 60 provides that oral evidence must be direct. This means that a witness can tell the court of only fact of which he has the first-hand personal knowledge, in the sense that he perceived the fact by any of the five senses. That is, oral evidence must be direct. That means whatever the witnesses they have seen of the occurrence of such incidents. Whatever the witnesses they have seen, they have been heard, they have been perceived of such incidents with their own five senses. It comes under the oral evidence must be direct. That means by producing the witnesses who have seen, who have perceived by their own five senses, these witnesses must be produced in the proceedings of the court. Then only the accused persons can be either acquitted or can be convicted based on the statements of such witnesses. Here, now you see section 61. Here, this section 61 provides about the proof of contents of documents. Here, the contents of documents may be proved either by the primary evidence or by the secondary evidence. Here, section 61, it expressly provides that the contents of the documents can be proved either by the primary evidence or by the secondary evidence. Now, section 62. Here, section 62 provides about the definitions of the primary evidence. Here, primary evidence means the documents itself produced for the inspections of the court. Section 62 provides about it. Whatever the documents itself produced for the inspections of the court, it comes under the concept of the primary evidence. Here, the expressions of primary evidence of a document is defined in section 62. The following four are included in the expressions of primary evidence. Here, what documents will become under the primary evidence? Now you see, number one, the original documents itself produced for the inspection of the court. Number one, whatever the original documents produced for the inspection of the court, it will be considered as the primary evidence. And secondly, where a document is executed in the several first, is for this primary evidence of the document. Here, suppose a document is executed in several first. Now, is part of the execution of documents, it will be considered as the primary evidence. Here, number third, where a document is executed in the counterfeit, that is counterfeit is primary evidence against the party signing it. Here, in case In case of a shack, hmm, baked shack, the main shack is shined by the drawer, so that it is primary evidence against him, and the counterfoil may be shined by the fee of the shack, so that it will be a primary evidence against the fee. Hmm. Here, this comes under the concept of the primary evidence. Hmm. Here, and number four, where a number of documents are all made by one uniform process. Hmm. As for example, by printing, by lithography, or photography, is primary evidence of the contents of documents. Yeah, this is also comes under the primary evidence. If the documents are made in one uniform process, it may be by lithography, it may be by photography, or it may be by printing. If it is in one uniform process, if the document is made, then each document will be considered as the primary evidence. Here, now section 63 you see, here it provides about the secondary evidence. Here, secondary evidence means and includes here certified copies give hands under the provisions hereinafter contained. Whatever is certified copies from the concerned authority, it comes under the secondary evidence. And copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy, and copies compared with such copies. Now, second one is the by mechanical process, whatever the copies made, and these copies will ensure the accuracy of such copies. Then it will consider this the secondary evidence. And copies made from or compared with the original. This also comes under the secondary evidence. And counterfeits of documents as against the parties who did not execute them. Yeah, whatever the documents issuing in the counterfeits, if the party they did not execute such documents, then this counterparts will be considered as the secondary evidence. Yeah. Now the oral accounts of the contents of a document given by some persons who has himself seen it. Now the oral accounts of the contents of the documents, the persons who have seen such document himself, it will be considered as the secondary evidence. Here, now section 64, it provides about the proof of documents by primary evidence. Here, documents must be proved by primary evidence, except in the cases hereinafter mentioned. That is, yeah. Section 64, it is given obligations, it is given mandatory to the court proceedings that every document must be proved by the primary evidence. But in some circumstances, whatever mentioned in section 65, under these conditions only, the secondary evidence it is allowed. Now, you see the secondary evidence. Cases in which secondary evidence relating to documents may be given. Here, Section 65, it provides about the some conditions, some circumstances under which the secondary evidence can be produced in court proceedings. Here, now you see number one conditions. Here, when the original is shown or appears to be in the position or power. Suppose the original is in the position of number one of a person against whom the documents is sought to be proved. Suppose if the original is in the positions of the opposite parties, it may be on the defendant side, it may be in the defendant position. That is, and if of any persons out of reach of and not subject to the process of the court. Now, second conditions, if the original is on such a person which is out of reach or which is out of the process of the court, yeah, if it cannot be produced without unreasonable delay or expenses, in these cases, the secondary evidence will be admissible. And any persons legally bound to produce it. Here, and now document is in the position of such a person who is legally bound to produce this original document. Here, if the original document is on such persons, and if the court, by given the notice to such persons, if they are not produced such original documents, although the notice is due sharp to such parties, here the secondary evidence on such documents will be admissible. You remember that notice must be served to such persons who have been possessed such original documents. By duly serving the notice, if such parties who possess the original document, if they doesn't produce the such documents, then under these conditions only, secondary evidence will be admissible. Here, and number two conditions, when the existence, conditions, or contents of documents have been proved to be admitted in writing by the party against whom the document is to be proved or by his representative in interest. Yeah. Now, second conditions. If the party themselves they have admitted in writing whatever the contents of the documents, in these cases, secondary evidence will be admissible. And thirdly, when the original has been destroyed or lost, or when the party offering evidence of its contents cannot, for any other reasons, not arising from his own default or neglect, produce it in a reasonable time. Yeah. Now, if the original documents is destroyed or lost without his own neglect, without his own negligence, without his own default, in these cases, secondary evidence will be admissible. Suppose original is lost, destroyed in these cases. Here, the secondary evidence will be admissible. Here, now, when the original is of such a nature is not to be easily movable, hmm, this would include cases of bulky documents. Here, now the next condition is the bulky documents. It means the documents which are in very large size, which cannot be easily movable. In these cases, the secondary evidence will be admissible. That's why in the contents of the documents, we have got a very comprehensive sense, in very wide sense. Whatever written, it may be written in wall, it may be written on some objects. That is, it also comes under the concept of the documents. Document definitions has been given very wide in our Indian Evidence Act 1872. That's why in cases of the bulky documents, you remember that bulky documents in very large size, which not be easily movable. It may be in written of the wall, or it may be written in some objects which is not easily movable, which cannot be easily produced before the court proceedings. In these cases, secondary evidence will be admissible in court proceedings. Here, now, when the original is a public document within the meaning of section 74, and when the original is a public document, in these cases, by the help of the certified copies from the concerned authority, secondary evidence will be admissible. And when the original is a document of which the Evidence Act or any other law of the country permits certified copies to be given in evidence. Now, when the original document is such a document in which by our Indian law, which is in force now, if it is allowed the certified copies to be admissible as a secondary evidence, then the secondary evidence will be given by the certified copies before the court proceedings. And when the original consists of numerous accounts or other documents which cannot be conveniently examined in the court, and the fact to be proved is the general result of the whole collection. Now, next condition is about the general accounts of the contents of the documents. Yeah, in these cases, yeah, whatever the general result of the whole collections, it can be produced as the secondary evidence. Now, we could see such cases in a citation of some reference cases, citation of some provisions at the moment of the pleadings before the court proceedings by the learned counsels, whatever they have been cited, it comes under the concept of the precedents of the previous judgments, whatever the court they have been held judgments regarding these large accounts of books. If the judges, learned counsel, they have quoted some provisions, some important accounts of these judgments, it comes under these general accounts, general results of the whole collections. You have to be remembered about it. It comes under the secondary evidence. Here, now the section 65A. Here, it provides of the special provisions as to evidence relating to electronic records. Here, section 65B. It provides about the admissibility of electronic records. This section prescribes the mode for probable contents of electronic records. Here, now we go to section 65A and 65B. It provides about the special provisions of the electronic records and the procedure for the proving of the electronic records. And now section 66. It is provides about the rules as to notice to produce. Yeah, this section also shows us relevance with this modes of proof. You have to know about this. Yeah, it provides about the rules as to notice to produce. Yeah, under clause A of section 65. Here, whatever this section 65 clause A, it provides that if by duly serving the notice to the parties, if they are not produced the original documents, then the secondary evidence could be uh, produced before the court proceedings. Now, when the notice is not necessary, as for section 66, here section 66 provides about it. In some circumstances, notice to the parties who possess the original document in their possessions, yeah, need not to serve the notice to such parties. Yeah, uh, such notice is, however, not necessary in the following cases, and secondary evidence can be given without notice. Yeah, secondary evidence can be given without notice to such parties in some cases, in circumstances. It provides under section 66. Now you see number one conditions. Here, when the document is a notice by itself. When the document is a notice by itself. Number one condition. And second, when the nature of the case itself makes it clear to the party in possession that he will be required to produce it. Now, second condition. Yeah, suppose the nature of the case is that the party who possesses the original, they must have been obliged to produce the original documents. If they doesn't produce the original documents, yeah, the secondary evidence could be produced without giving notice to such parties. And in number third conditions, when it appears or is proved that the other party has obtained possessions of the original by fraud or force. Yeah. Now, if appears to the parties or in court proceedings, then if the party who possessed the original documents, if they had been possessed by means of fraud or by means of force, in these conditions, without giving notice to such parties, secondary evidence will be admissible. And number four conditions, when the adverse party or his agents already has the original in the court. Now, number four conditions, when the opposite party, that is the defendant, or either it may be plaintiff or it may be defendant, when the adverse party or the opposite party uh, has original in the court, when the adverse party or its agents already has the original in the court. If either party they have original in the court, In these cases, without giving notice to the parties, here secondary evidence can be produced. If the original documents is already in the court, yeah, without giving notice to the opposite party or adverse party, yeah, secondary evidence can be given by the parties. Here, and number 5, when the adverse party or his agent has admitted that the original has been lost. Now, when the adverse party, opposite party, or its agents, they had been admitted that the original has been lost. In these cases, without giving notice to such parties, the secondary evidence can be produced in the court proceedings. And number 6, when the versions in the positions of the original is out of the reach of the court or is not subject to the process of the court. For example, that he is a foreign ambassador and therefore the court has no jurisdiction over him. Yeah. Now, last condition is that suppose the original documents is on such a person which is the out of reach or out of jurisdiction of the out of the process of the court. If such persons, such documents could not be produced without unreasonable delay or expenses. In these conditions, without giving notice to such parties. Here, secondary evidence, it can be produced in the court proceedings. Here, up to this, we have been clearly discussed about the modes of proof of the fact of relevant facts in issue or search and either in civil proceedings or criminal proceedings. Here we got the clear concept about the uh, oral evidence, about the documentary evidence, about the primary evidence, and about the secondary evidence, and about the under which conditions or circumstances secondary evidence can be produced in the court. And we got the concept of the notice, rules of notice provided under section 66, and under which conditions notice should not be served to the opposite parties. Here we got these concepts clearly in these presentations. I think we have got a clear concept under these presentations. Okay, that's all.